Ever wonder why companies can just voice their opinions on elections or political issues? It's kind of wild when you think about it. Well, today's deep dive, we're going to throw open the doors of the courtroom to examine just that.
We're talking about whether businesses have the same free speech rights as individuals.
Exactly. And to really unpack this whole debate, we're diving into, well, you guessed it, some legal jargon.
You've handed us excerpts from Justice Scalia's concurring opinion in the landmark Citizens United case.
Bingo. Now, that 2010 ruling, it really shook things up. So just as a quick refresher for anyone who, might not have the case memorized.
Which, no judgment here.
Right. Citizens United basically said corporations and unions, they can spend money on political campaigns, which, let's be honest, ignited a firestorm about money and politics.
A bit of an understatement.
For real. But for our deep dive, we're laser-focused on Scalia's concurring opinion. He agreed with the outcome, the whole corporations can spend money thing, but he took a different path to get there. And that's where things get really interesting.
It's fascinating how these legal minds work. So Justice Scalia, known for his, shall we say, sharp wit and his textualist approach, agreed with the majority, but offered his own distinct reasoning.
Right, like he wanted to make it clear, hey, I agree, but here's why I think it's right.
Exactly. And that why is where we're going to dig in.
Buckle up for some serious legal zingers, folks.
Yeah.
So where do we even start with this? A little background on the case itself, maybe.
Sure. So the case, at its heart, centered around a film. This film was critical of Hillary Clinton, and it was produced by, you guessed it, Citizens United, a conservative nonprofit.
Ah, okay. So we've got politics, we've got movies. This is already juicy.
Oh, it gets better. The real crux of the matter was whether the government could actually put restrictions on this corporate-funded political speech, especially because it was released so close to an election.
I bet that got people fired up.
You have no idea. And in a nutshell, the court said, nope, hands off. Basically, they overturned decades of precedent, which is a huge deal in the legal world.
Talk about a legal earthquake.
Totally. But here's where it gets really interesting. Justice Scalia's whole approach to interpreting the Constitution. He was a big proponent of originalism.
Originalism meaning? Remind me what that is again?
Okay, imagine you're trying to understand a text message, but this text is from hundreds of years ago. That's kind of what originalism tries to do with the Constitution. Scalia believed we should interpret it based on what the words meant when it was adopted, not through the lens of our modern values and beliefs.
So like sticking to the original script, no reading between the lines, no adding our own interpretations.
Precisely. And that leads us to Scalia's now famous line in this opinion. He says, and I quote, "The amendment is written in terms of speech, not speakers." He's super emphasizing that the First Amendment protects the act of expressing yourself, the actual speech, regardless of who or even what is doing the speaking.
Which is huge E for his argument about corporations, right?
Yeah.
He's saying, hold on, the Founding Fathers cared about protecting speech. They weren't trying to define speakers as just individual people.
You got it. He's drawing a line in the sand. Of course, this wouldn't be a good legal debate without some fireworks, right?
Oh, I'm sure there's a counter-argument in there somewhere.
Oh, absolutely. The dissenting opinion argues that the founders were actually wary of corporations, a little suspicious, maybe even a little.
Really? Were corporations really that hated back then?
Well, that's what the dissent argues. They say because of this supposed aversion to corporations, the founders couldn't have possibly intended to give them these broad free speech rights.
So it's a showdown. Intent versus the actual words on the page. Classic constitutional clash.
Exactly. And that's where Scalia throws down some serious historical knowledge. He's not just going to let that dissenting opinion slide.
All right, this is getting good. Give me the details.
Okay, so Scalia, he challenges this whole idea that corporations were insignificant or, universally despised in the founding era. He points out that by the late 1700s, hundreds of business corporation charters were granted in the newly formed United States.
So they weren't exactly rare creatures then.
No. He even quotes a scholar who describes this as unprecedented growth.
Whoa, that's quite a shift in perspective, isn't it? It really makes you wonder how often our perception of the past is colored by, our present-day lens. We look back with our current opinions and assume things were always that way.
It's human nature, but it doesn't always give us the full picture.
For sure. Okay, so if the founders weren't totally anti-corporation, What were they so worried about? What was at the root of all these concerns?
Scalia says it wasn't corporations themselves, but rather the special privileges some of them enjoyed. Back then, certain corporations got special favors, advantages granted by the government, that stifled competition.
Ah, so it's not about being a corporation, it's about having an unfair advantage.
Precisely.
Yeah.
And Scalia emphasizes that modern corporations, they don't usually have these kinds of privileges. They operate in a totally different context.
That's a really interesting distinction to make. It's like comparing apples to oranges. The corporations of the 18th century were often these massive government-backed entities, and today we've got everything from like your local bakery to multinational conglomerates, all operating under the same corporation label.
It's a good point. It's easy to just slap a label on something without, really understanding the nuances.
Exactly. And Scalia, he doesn't stop there. He makes this like super clever connection to the freedom of the press, which I thought was brilliant.
Classic Scalia, always connecting seemingly totally different ideas. What struck you about that part of his argument?
Well, he brings up the fact that back in the day, newspapers, they were often owned by entities, not just individuals.
Yeah.
Like it wasn't just one person cranking out their opinions on a printing press.
True. Those early printing houses, a lot of them were set up as partnerships or even early forms of corporations.
Exactly. So Scalia is basically saying, if you're going to argue that corporations can't be speakers under the First Amendment, well, wouldn't that logically apply to newspapers too? And that's a whole other can of worms.
Precisely. If the government could restrict corporate speech so broadly, what's to stop them from censoring newspapers just because they're structured as a company?
It's kind of a slippery slope argument, but it really makes you think.
Oh, for sure.
And all of this, it builds up to what I see as the crux of Scalia's argument. The idea that people often speak through groups, and those groups, those associations, they deserve protection too.
Right. He argues that individuals, we rarely just go through life speaking only for ourselves.
We team up.
Exactly. We join political parties, unions, churches, advocacy groups, you name it. We combine our voices to try to, make things happen, to support causes we believe in. And corporations, they're just another form of association, aren't they?
Right. It's a group of people coming together to, in this case, pursue a business venture. So Scalia is saying that shouldn't automatically mean they lose their First Amendment rights. It's no different from, like you said, forming a political party or joining a union.
Exactly.
Which, this brings up another tricky point.
Right.
Because some of these speakers, corporations, unions, they have way more resources than your average individual.
Yeah.
And that's where this whole debate about money and elections, it gets really complicated.
The million-dollar question, literally. And Scalia, he doesn't shy away from that complexity. But his core point, it always comes back to this. If we accept that the First Amendment protects the act of speech, then saying, okay, but you can't speak because you're a corporation, that sets a dangerous precedent.
Because who gets to decide which groups can speak and which can't? Where do we draw the line?
And for Scalia, that line, that bright line, is best drawn by going back to the text of the First Amendment, sticking to those original words, rather than trying to guess what the founders may have thought about corporations.
It's like you said, sticking to the original text like that. It's not always so simple, especially with a document written centuries ago.
It's true. It makes you think, if we're sticking to those original interpretations, what other legal interpretations might need a second look? Think about the explosion of technology, the questions about privacy in the digital age, even how we view the role of government in the 21st century.
It's a whole other can of worms.
It really is.
And that's why Scalia remains such an intriguing figure. You might agree with him, you might not, but you can't deny that his opinions always make you think.
Without a doubt.
Yeah.
Now, before we wrap up our deep dive into Scalia's take on Citizens United, it's important to remember we've just looked at one piece of a much larger puzzle.
Totally.
Yeah.
We haven't even begun to cover the countless other arguments for and against corporate political spending, the impact of Citizens United on campaign finance, or the attempts to regulate it.
Exactly. And this isn't just some abstract legal debate either.
Right. This stuff, it plays out in our lives every single day.
It really does. Every time a company speaks out on a social issue or you see a political ad funded by an organization, you're seeing the ripple effects of this very ruling.
It's everywhere.
Everywhere. And it raises some really important questions for all of us. If corporations have these free speech rights, well, what responsibilities come with them? How do we make sure our democracy isn't drowned out by the loudest voices? Especially when those voices often belong to the entities with the most resources.
It's a tough balancing act, and there's no easy answer. But for me, what's so interesting about Scalia's opinion is that it pushes us beyond those surface-level arguments. It makes us wrestle with the core principles at play. It's not enough to just say corporations shouldn't have free speech or money talks. We
Right.
have to dig deeper. We have to ask ourselves what kind of society we want to live in.
That's the beauty of engaging with these complex ideas. It's not about finding all the answers right away. It's about asking those tough questions, thinking critically about the information thrown at us, and participating in these conversations about the future of our democracy.
Could have said it better myself.
Yeah.
So as we wrap up this deep dive, we want to leave you with something to consider. Think about the last time you saw corporate speech in action. Maybe it was a company taking a stance on a social issue or a flood of online ads during an election. Now ask yourself, how much do those messages influence your views? How do you navigate this landscape where corporate voices are often amplified? This deep dive has given you the tools to think critically about these issues and to better understand the complex interplay between free speech, corporate influence, and the future of our democracy.
Keep asking those tough questions and keep the conversation going.